joining us for today's meeting. You've received the agenda that Amy sent out. And so we'll start off with that. Amy's going to give us an overview of what lies ahead before we start talking about our small group, the status of our small groups. So Amy, I'll turn it over to you.
Perfect. So I wanted to check in on two aspects of the work group. The first is working draft 4, which, as you all know, we have been really focusing on getting the information that Jessica needs to pull that together and to draft that. The goal is still to have that drafted in, I think, the next week or so, by August 1st. Jessica's nodding at me. And so we're really pushing towards that. The idea would be that we would share that with you all in August and get some feedback. I would also flag that while we've been pushing pretty hard the last couple of months to get and having these twice-a-month meetings, which has been, I know, a lot of work for folks, and I really appreciate it. We do have some time left. The goal here is to have this kind of working draft 4 that Jessica's going to put together, but we do still have some time to deal with some of the outstanding questions. For example, when we met last week, there was a question about protective orders and how that interacts with identifying who to serve. And we're not going to be able to get to that today, but we will have time to make some of those smaller, make tweaks over the next few months. So I don't know how many of you have looked forward on your calendar for the next few months, but we do have meetings scheduled through December. We will continue to meet, and we will continue to kind of talk through the issues that didn't get addressed quite yet. I will flag that one of them was the municipal proposal that excuse me, I have Judge Zumper, I have to let her in. Excuse me. The municipal language that Jim Nash shared last week. We think that we can have that conversation after this meeting today. And there's a couple other things too, and I have my list if you just give me a second to pull it up. The protective orders, as I mentioned, Jim Nash's municipal proposal. There was some feedback on section 16 we haven't addressed yet. There was a couple other things. Of course, the default judgments. We're going to have a small group meeting about that today after the full group meeting for the first half hour. And then we're also going to talk about scope of review today. So if there are things there that didn't quite get addressed today before that drafting is done, we still have some time to kind of dive into those smaller pieces. And I'm sorry, Judge Cross. We do have time. So thank you to everyone for putting in just an incredible amount of work the last couple months, and very much appreciated. And we do have time to do what we're doing now, have this conversation today, and then once we see that bigger draft, we'll be able to take that time and go back and do the fine tuning and the changes that as needed. So that's kind of where we are in the process. The next meeting is August 14th. And if anyone has any questions, I'm happy to answer them now, or you can shoot me an email, or Krista or Justice Duncan, obviously, too.
And Amy, just to recap, we will be, and Jessica as well, will be getting a working draft before our next meeting. People will have a chance to review that before we talk about it in the August 14th meeting. Before that meeting, we will solicit and welcome feedback so that we can move efficiently at the August 14th meeting. So we will work with what we've got in what will be working draft 4 in August. And like Amy said, there's a couple other issues just because they will not appear in the working draft 4, like the municipal court scope of review, municipal court limitations on review issue. Doesn't mean that we're not going to talk about them. Those are just issues that Jessica has identified as things that we will be able to basically add on. They're not kind of integral to the structure. So those are things we can still take up. If you have any questions about anything that you see when you get working draft 4 that's not covered, let us know. But please be aware there are some things that we know will be in working draft 4. Jessica, before we move on, anything else you want us to know about process or our steps between now and our next meeting?
The only thing I would add is a little bit of a caveat, which is that there is a lot of information to synthesize into this working draft, and I will do my very best to get it right based on the notes that I have, the feedback that was shared, the different versions of language that are floating around. It will not be perfect, so I just want to put that out there, and that's why we have this additional time to, talk about any issues that might arise.
And we greatly appreciate all the work you're putting in on this, and Jessica, and we fully recognize that you are dealing with not just months, but years of information and discussions and trying to figure out where we've landed on some things, and we will review the working draft with all of that in mind and understand that it is a working draft and there's room for editing and clarification. So I hope we'll all approach it with that view. I know we will. So that's our process. We're doing great work. Thank you for all of your efforts, and we are really advancing the ball and looking forward to working draft 4 and seeing what's left after that. Hopefully not too much, so that we remain on schedule for our submission, timely submission for the legislature and the upcoming session. So that completes our first agenda item. As Amy said, both now and in her email, we have divided this meeting into 2 groups because basically we're updating you on process, and we'll update you on the small groups, with the second half of the meeting was just for the default group, folks who are going to use the opportunity to touch base again on their project, because we want to maximize the amount of the opportunities that we have for tying up these ends. We have now we'll move to the small group proposals. We have a group of folks who've been working on a scope of review and whether courts should retain or remand cases. You received just with the agenda, so we know you may not have had a chance to fully digest everything, but we want to put this on your radar. You received it in the agenda. It is a memo that Jimmy Brewer has prepared as a discussion of what's happened in that group. And please do review it. And we would like your feedback. Amy, our timeline on feedback, Amy and Jessica, our timeline on feedback for this one is written feedback, right? And did we set a time? We'd like written feedback in the next week or so if you can. Is that right? That work?
So what I understood from Jessica, and please correct me if I'm wrong, Jessica, is that if you want to provide feedback for working draft 4 on this language, we do need it pretty quickly. So Jessica, I believe that it's by the end of the week. So it is a tight turnaround, and we appreciate that it is a tight turnaround. But we do have more time also afterwards. It just might not make it into Jessica. I'm sorry, Jessica, I won't speak for you. You go ahead.
No, I was just going to add that the kind of feedback that I would be able to incorporate that is received later this week would have to be like there's clear consensus. I think the default needs to be, I will treat this small group consensus memo as how the work draft will look, unless I hear clear consensus otherwise to make changes. Because otherwise I can't really make a decision on what should and shouldn't go into the work draft.
So we have Jimmy, who's going to give us an overview of this. And if you've had a chance to look at the memo, you'll see that Jim has a recommendation at the end of the memo too. So just is it a process question before we go into their descriptions? I see your hand up.
Maybe I'm wrong. I don't think I've received this memo.
Oh.
When was it sent?
It was sent Monday.
Okay.
And
Maybe
I can resend it to you if that is.
Would you do that, please? Maybe I got it and I just don't recall seeing it. It's possible. It's been a busy couple days, but if you could resend it, I'm sure I have it, that'd be great. Thank you.
I'll do it right now.
Great. Amy, do you just want to send it to the group so that's at the top of, is it easy to send it to the whole group so it's at the top of everybody's email and they can just pull it up as if they need to, as Jimmy and Jim?
I'm happy to do that. Just give me a quick second and it will go back out to the, in just a moment.
Jimmy, while that's happening, would you mind giving us an overview, giving the overview of the memo?
Sure, I'm going to give, I think, just a general overview. I'm not going to spend too much time and go through every provision. It's all in the memo with some explanations. And I should say at the outset, the memo is prepared by both me and Jim Nass. He did a lot of work on this as well. He has his own section representing his views at the end, but the majority of the memo is from both of us. So the two issues we were dealing with had to do with the scope of review, which is to say, in an appeal of a particular type, what should the circuit court be doing? And then the remand question, retainer remand question, which is basically when the circuit court is done doing that, what should it do then? And those questions both intersect as a policy matter with what types of things from the Justice Court should be appealable. And so we've made some adjustments to those as well to accommodate situations where we felt there isn't really anything productive we can do in the circuit court on this type of thing, so maybe it shouldn't be appealable at all. So most of that discussion took place in terms of like specific categories of appeals, but we do have a general statement that when a defendant or when either party appeals, the circuit court should be limited to the matter that's on appeal. That matter could be everything in the case of an appeal from a judgment of conviction. The matter could be a motion to suppress in an appeal from an order denying a motion or an order granting motion to suppress by the state. But you appeal, a restitution judgment, that's not going to result in a complete retrial. That's going to be more limited. The one, I'll just sort of generally walk through how we're dealing with various appeals by the state, by the defendant in the state. Appeal from a general judgment of conviction in the Justice Court, that's going to be the same. You get a new trial. The one difference is in guilty and no contest plea cases. Under current law, it would not be appealable in a guilty plea case, but seemingly be appealable in a no contest plea case, and you could get a new trial. This splits the difference. If there's a guilty or no contest plea, you do go up to the circuit court, you get a new sentencing, but the plea stays intact. You don't get a new trial. Your guilt has already been determined. One nuance to that has to do with conditional pleas. During discussions, I think we realized that conditional pleas don't really work going from the Justice Court to the Circuit Court. So we amended the procedural language basically saying you do not get to enter a conditional plea in a Justice Court that's not a court of record. And of course, we're only talking about not court of record justice courts. In a court of record justice court, it's just the same as a circuit court. But we are creating a new procedure for basically a late transfer, basically a situation where both the justice and both parties agree that a transfer is appropriate upon the denial of a defendant's motion. They can sort of all get together and agree that the case should be transferred to the circuit court. This would really be for cases where everybody in the courtroom realizes, oh, this is going to be an issue for the Court of Appeals. We're not going to have a final resolution to this until it goes up there. So speeding that on its way. But that would be a pretty limited procedure because everybody has to agree to it. And that would replace conditional pleas. Other types of appeals, appeal from a restitution, supplemental judgment, that's going to result in a complete new resentencing in the circuit court. Appeal from a probation revocation, that's the only category of probation-related appeals that's going to be permitted, and that's going to be limited to basically just redetermining that question in the circuit court. In terms of state's appeals, state has appeals both from stuff that can be decided before trial and after trial. The after trial stuff is new, the before trial stuff existed in current law. In all of those appeals, the general thing that would happen is that the circuit court makes a decision on just the matter on appeal. In terms of the pretrial appeals, though, and this is when we sort of segue into the question of what should the court do next, both in terms of pretrial appeals, like an appeal from the denial of the motion to suppress, either party can request that the case just stay in the circuit court. And that would mean that, for example, state appeals the grant of a motion to suppress, circuit court rules the other way. The defendant says, well, okay, if that's the case, I'm just going to enter a plea because there's nothing to try here. That can just happen in the circuit court right then and there, rather than having to go back to the justice court and then potentially be appealed back to the circuit court again so that the defendant can get to the Court of Appeals. So that's a sort of procedure that permits some efficiencies in certain cases. In terms of post-trial appeals, we didn't really have as much of a consensus. So basically what we've gone with is that would be remanded to the justice court after the circuit court makes a decision. In cases where it's not remanded, and those are going to mostly be defendants' appeals from the general judgment, and this gets into the retainer remand question. Current law, based on Court of Appeals precedent, is that the circuit court is supposed to enter its own new judgment in cases where it holds its own trial or its own sentencing. The circuit court is going to be entering its own judgment. And the consensus, and Jim Nast disagrees with that, and he'll speak about that in a moment, but the consensus is to retain that. Circuit court is going to be entering its own judgment in cases where the trial occurs in the circuit court or in cases where the circuit court sentences the defendant. In other categories of cases, there is the possibility of remand, as I sort of discussed above, in the state's appeals. That's going to be an option that's available of remanding, and in some cases, the only option of remanding to the justice court. So the circuit court wouldn't be entering its own judgment in a case where the state appeals from a motion, an order granting a new trial. That would be, if the circuit court disagrees or agrees, it'll enter an order either affirming or reversing and sending it back to the justice court. In terms of the one other nuance on the circuit court entering its own judgment is that there's also agreement that the justice court should be able to enforce that judgment, or at least monetary provisions in it. That appears to be the current practice, but there's nothing specific in current law that necessarily creates a uniform method for doing that. There's some, I would describe it as placeholder language that kind of reaffirms that in what we have proposed, but there was also some discussion that maybe there should be additional consideration of what precisely that language should look like or how precisely that should work. So that may be subject to change, but the general idea of it, that the justice court should have the authority to enforce those judgments, even though they're entered by the circuit court, that I think is something we do agree on. I think I've covered everything. I've done it in kind of an abbreviated manner, but like, as I said, the memo goes into more detail, and I don't really have anything to add to that.
Just this kid's hand up.
Does your, I think in general, it sounds fabulous. So thank you for clarifying, right? Like, thank you for that important work. Does your proposal tell us what we should do, whether we should stay our judgment while it is on appeal? For example, sometimes we order a traffic course. What should we do about that?
So I think that kind of falls outside the scope of what we were considering. I think there may be a separate provision somewhere in here that permits a stay but doesn't require it's not automatic. But I don't recall offhand because that wasn't something I was focused on.
Okay.
Anything further, just this kid, and if not,
I think we should specify one or the other, right? And I don't have a preference about which one it should be, but I think that would reduce some ambiguity about what we're supposed to do and what defendants are supposed to do in the meantime.
we do have a provision on stays in the existing law and in the working draft, and we can just make a note. And that's not the sections that this small group was working on, but we can make a note to make sure that this issue is covered in the stay section, or just keep watching it to make sure that whatever the stay section in working draft 4 says, that it addresses your concern.
Okay.
And across the top of my screen is Judge Cross. Oh,
Thank you. I don't think there was quite the degree of consensus as Jimmy does with regard to the circuit court being allowed to retain the case at the request of either party. I seem to recall that both Judge Brisbane and I were not on board with that. Our position has been that the circuit court is acting as an appellate court, just as if it were in the circuit court and went to the Court of Appeals, and circuit court makes a decision, they should remand these cases back to the Justice Court. And that I continue to maintain that as my position. And I don't think that I certainly would not like to see this change be put in here. With regard to again, same thing with regard to the Justice Court enforcing a circuit court orders. I just think that's, again, the circuit court should simply remand it and say this is the order that the Justice Court shall enter with regard to whatever the fine is in a traffic case. The Justice Court then enters an order, which the Justice Court then enforces. That to me is the appropriate mechanism for that. So I think that I recall there being more kind of debate and not quite agreement than Jimmy does.
so two issues you flagged. One is whether the case should stay in the circuit court. And question for those of you in the group, it seemed, how clear was existing law about the practice of this? Anyone?
So in terms of the circuit court entering the judgment, that's super clear under Court of Appeals case law that goes back to 1976. That's in cases where the defendant appeals, the circuit court holds the new trial, enters its own judgment. That is current law.
Okay.
I think Justice Cross is correct that he did express concerns about the retaining in certain states appeal cases. I think that's correct.
Well, or if it's an appeal from a pretrial motion, yeah, essentially what I thought you were talking about, and correct me if I'm, was the case goes, there's an appeal of a pretrial motion.
Yes.
Usually, and that's going to be a state appeal. The circuit court makes a ruling, and assuming that it's an adverse ruling to the defendant, then you're saying either party can elect just to stay there and have the case tried in the circuit court. And I don't agree with that, and I don't think Judge Brisbane agreed with that, and there may be some other folks, I'm not sure, because we didn't actually take a poll, but I think the case should be remanded to the Justice Court with whatever the ruling is from the circuit court on the evidentiary matter, and proceed to be litigated there. That would be the appropriate outcome with regard to that. And the other thing would be and again, I haven't had a chance to read this all yet, so I'm just trying to, I'm picking out a couple things quickly, and I'm not saying there might not be something else, but those are the two that kind of leapt out to me.
Great, and we will flag those and people can provide feedback on them. One thing that I would just mention on like if you have a pretrial motion to suppress appeal by the state goes to the circuit court. One question I would have is if we send it back, then the Justice Court's going to have been reversed on the ruling on the motion to suppress. You'll have your trial at the Justice Court, and then the defendant in the scenario may still want to appeal that to that decision to the Court of Appeals. So I'm wondering, it would go from the circuit court back to the Justice Court for a new trial, then to the circuit court for a new trial, all to get it to the Court of Appeals.
I think what I would suggest is if a defendant files a notice of appeal of the circuit court's order, then obviously there would be a stay on anything in the Justice Court pending the case being resolved in the court in the appellate process.
Well, unfortunately, there's no ability for the defendant to appeal from any interlocutory order by the circuit court. Defendant can only appeal from the final conviction.
So
Jimmy, you're right. I wasn't thinking that through. You're right. So
This scenario could be something that we can all think about as we look at the memo. That might help us decide whether this flexibility should be allowed.
But the Justice Court final order, since the only issue in that appeal is going to be that what happened in the circuit court, the Justice Court's final judgment will then, assuming the defendant then were to lose, then they could appeal the circuit court order, and the 30-day period wouldn't start to run until the Justice Court trial judgment was entered by the court. So I still don't think there's any issue with regard to that.
So I'll flag that. We're gonna go, I see Lindsay's hand is up, and then I see Heather's hand. Then we'll close to 12:30, which is when this group is, well, we have Jim's, maybe we've got Jim's additional remarks on the memo, and then this meeting will end and the default group will meet. So Lindsay.
Thank you, Justice Duncan. I was not able to attend the last meeting of the small group. And so I just want to add that I have some concerns about the Justice Court enforcing the judgment of the Circuit Court and how that would interact with current statutes. I think there are some provisions in Chapter 18 that talk about a judgment. If there's a money award in a criminal action, it's only enforceable by the state because it would be a money award in favor of the state as the judgment creditor. So I just am curious how those will interact together. And there might be other statutes, maybe in Chapter 1 that governs when circuit court judgments go to collections and when judgments have to be sent to collections in the Department of Revenue. And I think there's some other provisions as well. So just wanted to flag that. I'm in the process of touching base with our financial folks at OJD, and I'll provide some written feedback on that. But I just wanted to put a little placeholder there.
Thank you, Lindsay. And that will be helpful, especially if they can comment on what the current state of the law is. Because if we don't have consensus, we'll stick with what the current state of the law is. My understanding on this issue is that there's perhaps a gap in the current law that we're trying to fill, but I'm not positive of that. So if your folks can say this is what the current law is, and here's how the proposal would relate to that, that'd be really helpful. Thank you. And Heather and Jim.
I had a question around appeals in no contest cases. If I understood correctly, current law in justice courts that aren't courts of record, the only limitations are on guilty pleas, and of course that's different from courts of record. But I think I'm understanding that this proposal would place new limitations on no contest pleas, and I was just wondering about that, what the thinking was behind that.
Sure. So that's correct. This does change current law and limits the review in an appeal in a case where no contest plea was entered. I couldn't figure out that. It seemed to me that there was no reason for treating no contest pleas the way that current law does, other than the fact that whoever wrote the statute forgot that no contest pleas exist. Like it says, you can't appeal from a guilty plea, but it doesn't say anything about no contest pleas. And in that sort of gap is where we have this law that if you enter a no contest plea in the justice court, you can get a whole new trial in the circuit court. So it seemed to me like an error. There's pretty much no other place in the law where we treat guilty and no contest pleas differently. So it seems very odd that you would do that here. That was basically my thinking, is that whatever we adopt should apply to both guilty and no contest pleas equally.
And I know no contest plea is something this group has talked about, so maybe, and I think there was some discussion about how people will sometimes enter a no contest plea so that they can do the appeal as opposed to a guilty plea. I don't know if Tony or Heather, or perhaps you talking to Jordan, can tell us about, report back on whether this change would alter practice. I'm not sure, but you guys are in a position to find out. Maybe you can let us know. And especially if you know whether there would have been any reason for the different treatment, why you could appeal a no contest but not a guilty plea, because what Jimmy was saying, and there's not an obvious one. It could be just an omission. Thank you. And then with that, we'll have Jim talk about the portion of the memo where he's identifying a different approach. Jim?
Yes, thank you. Jimmy correctly reported that the current state of the case law is that on appeal from a justice court in both a criminal matter, that is a violation or misdemeanor matter, and apparently in a civil case too, that because the circuit court scope of review is de novo, that the circuit court's only option is to enter a whole new judgment. I haven't had a chance to read that State versus Lyman case to determine whether the court even acknowledged, however, that both ORS chapter 53 and 157 explicitly state that one of the powers of the circuit court is to remand to the justice court with instructions to do X, Y, or Z. I hope this is not like that State versus Polanski case where the court simply decreed something without doing any statutory analysis whatsoever. It's very disturbing to me. The legislature could not have been clearer with respect to appeals from justice court that the circuit court's power includes the power to remand. And yet in State versus Lyman, the Court of Appeals said, well, no. Well, so you have this odd conflict between statutory law and case law. Of course, as a work group, we're free to we are free to recommend to the legislature either to adopt either view or some other view. I'm of the view that the circuit court ought to at least have the power to affirm the lower court's decision. And that's for two reasons. First, there's a little bit of judicial efficiency if the circuit court, instead of entering a whole new judgment, is simply affirming what either the justice or municipal court has already done. But perhaps more importantly is this whole issue of enforcement of the judgment. If what the justice court or municipal court is enforcing is its own judgment, which has been affirmed on appeal, then you avoid all of the questions you have about whether a justice or municipal court should be enforcing a judgment of the circuit court. And even if it should, what are the mechanisms and how do you actually do it? So, and my review of 2 years worth of justice and municipal court appeals to the circuit court showed that the circuit court was affirming the conviction and imposing the exact same fine in about 3/4 of the cases. And so I think reinstating or making clear that the circuit court power, at least to affirm the lower court decision where it agrees that the defendant is guilty and would impose the same fine, that the circuit court power includes the power to simply affirm the lower court, and which would then free the justice or municipal court then to enforce its own judgment. I feel less strongly about civil cases, whether the circuit court should have the authority to reverse and remand or affirm. I don't have any experience in civil cases, so I can't speak to that. All I can say is that current law on appeal in civil cases from justice courts allows the circuit court to remand with instructions. And so unless there's a good reason to change that, I think we should leave it.
I see Lindsay's hand up, and I was actually gonna call on you, Lindsay, too, to see if those concerns that Jim is addressing or raising can be something that your group will let us know about. It sounds like current practice with regards to entry and enforcement of judgments is something you're going to look at.
Yeah, I can definitely do that. And I just had a clarifying question. Jim, are you saying that the circuit court should have the authority to choose to affirm and remand or to enter a judgment, or would it be in different circumstances, the circuit court may be required to remand rather than enter a new judgment?
Under current statutory law, it's unfettered discretion. There are no criteria in those statutes saying in these cases do X, in these other cases do Y. It's simply unfettered discretion. We might choose to put some limits on when that authority is exercised. I mean, certainly I'm of the view that where the circuit court changes some substantial, either finds let's say there are multiple charges, justice court convicts on all counts and the circuit court would convict on only one, or where the circuit court substantially changes the sentence, then it ought to be entering its own judgment. But where the circuit court reaches the exact same decision as the justice or municipal court, unless there's some good reason not to, I would think that in most instances, the circuit court should simply be affirming the lower court decision.
And I saw, and we'll call the folks' attention, Judge Kidd has put something in the comments. Jimmy's got his hand up. What, I'll have you go, Jimmy, and then I kind of want to just highlight the things that people should look at to get their, to make sure we're looking at all of the relevant statutes and case law on this issue to end the memo and can think about those and provide feedback. Jimmy?
Sure. So I'd say I disagree that the current law is quite as atextual as Jim believes it is, but I think my more important point is if the circuit court at the end of a criminal case does something other than enter a judgment of conviction, there are a lot of other statutes that would need to be changed to accommodate that, right? There are a lot of criminal procedure statutes, particularly in misdemeanor cases, stuff that applies after the conviction is entered, that is written on the assumption that the judgment of conviction is going to be entered after the trial in the court where the trial was held. And beyond that, entering something that doesn't meet all the requirements of a judgment of conviction would, for example, not be appealable under Chapter 138. There would be additional problems that are created that we need to be very careful about addressing. So that's my strong resistance to changing current practice on this or current law on this is there is a lot of other stuff that would need to be changed to accommodate that.
So everyone, if you have concerns about this issue, please take a close look at the memo. Jim, you flagged 2 statutes for our attention. Can you give those numbers to the group? And then Jimmy, you mentioned state versus, or it's Lyman, the Lyman case, or Jim mentioned Lyman, is that right?
Yeah.
You
Yes.
mentioned Lyman. Okay, so, and the statutes, Jim?
Gosh, they're in the memo.
And you just said them, they're in the memo, so folks, if you've got thoughts on these, please take a look at the statutes, look at the case law, look at the proposals, and send us an email with your thoughts. That would be great. With that, we've covered our portion of the agenda. Amy, Jessica, anything before we switch to just the default group? And see.
I would just reiterate, it does seem like there are some still outstanding questions. Again, I do need direction for this work draft. So my plan as of right now is to treat the memo as how we're proceeding. If we come to some consensus for the next few days via email, I'm happy to make changes. But again, I just need a decision one way or another.
And Jim and Jimmy, just because I keep calling on you as folks from the work group, is it correct that the memo proposal, except not Jim's other proposal, does the memo proposal reflect current law? Jimmy?
As to the specific issue that Jim and I disagree on, the memo proposal reflects current law. There are other issues, as I've noted, where the memo does change current law.
But on this issue, so Jessica, we'll give you the direction to go with the current law, because when the group can't reach consensus, that's been our default, so do that. But if you.
I think that the memo also does not necessarily reflect current law with this enforcement of the circuit court judgment by the Justice Court, because that's in the main body of the memo as a provision, and I'm not sure that that is current law.
Okay. Will we know that? Maybe Lindsay from your group will let us know.
Yeah, and I can send to this group I can look at the statutes and send my quick thoughts on that. I mean, I think we have a variety of practices across the state, but that's different than actually what the current statutory scheme is.
And I would agree with Lindsay that that new addition would be a change to, I couldn't find a statute that embodies it, but according to justice courts from several counties, that is currently what they do. So that is an area of uncertainty for me as well, but.
And if that is something, it would be new, so if we put it into the working draft, we will be able to pull it out. If we can't reach consensus, then it's inconsistent with current law. So does it make sense for Jessica to draft that and then we can pull it out?
Well, can I, Lindsay, if my thought, which was to have the circuit court essentially remand it back with a direction of what the judgment should be, and therefore the Justice Court or municipal court enters a judgment that reflects what the circuit court has held, and then it becomes, doesn't that solve the problem and it makes it enforceable by the justice and municipal courts? Because it's their judgment, it's their final judgment, not the circuit courts with regard to that fine or provision or sentence.
I think so. I mean, I'm specifically concerned with the judgment of the circuit court. I've looked at some of these, and if the state is the plaintiff, the state is the judgment creditor, and they would be the ones that, the circuit court would receive the money. It would be part of our collections process, and any money paid by the defendant, and then it would be distributed according to the regular fine distribution. It depends on the citing agency, how much goes to the state or to local government. And so that's how I believe we handle all of these cases when it's a circuit court judgment. If it's a local court judgment, then I think, the OJD and the circuit court doesn't have concerns about what the local court, how they enforce it.
And Lindsay, even if we get to the circuit court and the circuit court enters its own judgment, what I heard you just saying is that there is a distribution of money to other entities than the state. So it's not just that if it gets to the circuit court, the other entities aren't going to be receiving revenue under current.
I think that's right. And it depends also on if it's a local ordinance. So it depends on if it's a state V case or if it's a city or local ordinance that is at issue in the violation or misdemeanor proceedings.
I thought I saw a hand up, no other hands up.
I had my hand up really briefly. It does change some of the amount. It changes what would go to the Justice Court. Right, so a percentage of the money that is a Justice Court judgment goes to the county that hosts the Justice Court. But if it goes to the circuit court and then the circuit court enforces the judgment, then that money does not flow to the Justice Court, even though the Justice Court held the original trial. And even though OJD is receiving their appellate fee.
And to be clear too, the OJD, all of our money that's collected by the circuit court goes to the state's general fund or to the criminal fine account of the state or to the citing agencies. So none of it's retained by the circuit court. But I think you're right, Justice Kidd, that money does go that direction as opposed to staying with the justice court, the portion of the fine.
Thank you, that's helpful. So let's leave things there for this group. If you are a member of the default group, please do stay on the line. And for the next little bit, you guys can talk about open questions you may have. The rest of us, including me, are going to sign off, and we'll see you for our next meeting, which is August 14th. Between now and then, please, if you have any immediate concerns, let us know. Otherwise, keep an eye out for working draft 4, which will be coming your way. Thank you, everyone.
Thanks, everyone. I think this is us. Are you guys okay with Anne staying on the phone? Judge Kidd, I don't know if you've met Anne. She's our summer student. She's an incoming 1L. She starts at U of O in August. Thank you.
Welcome.
Thank you guys all for staying on, and we have a little less time than we had hoped for, but that is okay too. And I also wanted to thank you all for sticking with this conversation for as long as you all have. It's been going on for a while, and your willingness to come back and still talk about it is very much appreciated. My understanding is that you all are still interested in finding something, and I know Justice Kidd and Jim, you have also both expressed like the idea here is to find something that works, and that the existing law is not where you want to be. So we do want to find something to go forward with, and that's your interest. And so the goal today is to kind of figure out conceptually, where do we have a path forward? Do we have areas of agreement where we can move forward and give Jessica some guidance for this working draft 4? And as we talked about earlier today, working draft 4 is we've been literally working towards the working draft, but we still have time to tweak and manipulate that within the next couple of months. So we do still have that kind of opportunity to continue to do work. But in order to give Jessica what she needs, we need to kind of get somewhere so she can actually draft. And I did want to flag, I think you all know that Krista's out, so I'm here to help. I am by no means a subject matter expert in this area, and I appreciate very much the people who have spoken to me about this and given me feedback on what needs to be done or what needs to be where we want to go. And I know, Heather, that you had shared some stuff with Jim and Justice Kidd, and I wanted to give you a quick chance to chat.
Thank you. So I actually think that based on our dialogue, the emails that, particularly reading Jim's recent email and the email that I sent before that with some proposals that that they're very close to our original proposal, and that maybe there's not so much like light between our perspectives on what would make sense. And so I just wanted to highlight what I understand as like areas where we have agreement, and then also areas that I thought we were still maybe working on, and then see if that's how you understand it. So, I mean, it sounds like, having the motion to set aside a default judgment is the proper mechanism here. That's what the work group was originally proposing, and that's what the Court of Appeals said would be right. The Court of Appeals was pretty explicit that it wasn't going to then say how an appeal from that or what would happen from that after, like what that would look like. And so I think that's what our proposal was doing, and that it would be really helpful. And so some things that were in our original proposal were that, if there was a verbal request for a motion to set aside, that there just be something to ensure that there's like, that's noted somewhere, so we know that happened. And then because, you know, courts have sometimes that open time where people might show up to make those requests. And then we had recommended that that we allow an appeal of a denial of a motion to set aside a default judgment. And you know, that's something that's allowed from courts of record. And that's something that we had proposed in our memo. Some areas where I think maybe we might not have totally worked it out. So in our memo, we had proposed de novo review of those appeals, reviewing the motion, the denial of the motion. You know, I think because of the logistical concerns without a record to review. However, I think in the emails there, Judge Cross had also proposed in the alternative having review for abuse of discretion and having an evidentiary hearing, assuming that the evidence would be the same at the circuit court as it was below. So I think that's one area we haven't totally worked out yet. And then another being the disposition, which I think the conversation earlier today deals with this too. Like, so what happens if the motion is granted at circuit court, or the court thinks that a set aside would actually be appropriate? Does it go back to the justice or muni court, or and that was the original position of our work group in the memo that Jim wrote. And I think that that's maybe what's being proposed by the scope of review work group. Another option would be to just have it stay in the circuit court, or if I was hearing the scope of review work group correctly today, maybe another option could be to allow a party to just ask to keep it in the circuit court, and maybe the parties could agree. So just having an avenue that would allow it but not require it. And then something else that we talked about by email but not in the memo was maybe more explicitly incorporating the standards of ORCP 71 for the motions to set aside. And that's just like the civil procedure analog to the set aside statute that exists for violations. And we just thought that might allow for some more clarity. And I think Jim and I are the only ones who commented on that, so I don't know how others feel. And so I'll just stop there. That's what I see as like the areas of overlap. And I don't know. I feel like we probably could have a consensus on something, but I can be optimistic sometimes.
I guess because I'm hoping to kind of do this in a sequential way. And so I was thinking about how to talk about this and maybe start with the basics and move our way forward. So I was wondering if we could just kind of go through a series of questions and you guys can say, hey, I like this, hey, I don't like that, and give feedback on that. And maybe we can move forward that way if that works for folks. So I guess, and this might be really basic, and I appreciate your patience if I am being super basic about this, but at the get-go, do we all agree that folks should be able to file a motion for default judgment in the local court? I mean, at that very basic level, are we all a thumbs up on that? Is that something that we all agree on?
You mean in civil land, or do you mean in violations?
Violations.
Because it
You
just
need
sort
a
of
motion to set
happens.
aside a default judgment.
Yeah, Jessica's, and I am going to apologize in the front end. My terminology is, please feel to correct me. This is not what this is never what I practiced. And so I appreciate your patience as I'm trying to get there. But violations, motion for, yeah. And we're all, okay, good. Okay. Okay, second question. Do you all agree that it should be possible for someone to appeal an order denying the motion for relief from the default judgment?
Yes.
Okay, thank you. And this is, I think, where it gets a little bit more complicated based on my read of Jim's response to Heather's proposal. And so there's the kind of a couple levels of question. In terms of timeline, should that timeline for filing that for that motion, should it be consistent across the courts of record, the courts not of record, and the circuit courts?
Are we talking
Yeah.
about different deadlines or timelines? Like one is for the motion to set aside itself. And the statute provides, you know, within a reasonable amount of time, no more than a year. And then the appeal though would follow the usual like 30-day timeline for an appeal. Is that what others understand?
Yeah, true. Chase after you and kind of run around.
Oh.
1 hour. You can sort of.
I can't hear.
Jim, are you talking? There seems to be some noise coming from the background.
Oh. There's noise in the house, sorry.
Okay. My understanding it was as timeline appropriate for filing an appeal from an order denying a motion is the question I'm asking.
I guess my answer would depend on if it's a de novo question or not, right? If my worry overall is just like that we create an exception that sort of blows up the whole usefulness of the court, right? So if it is an abuse of discretion standard, right, then I think 30 days is totally fine. And I think the question then becomes, if it is an abuse of discretion standard, how do you get your record, right? And so one idea is, I actually think motions to set aside defaults are pretty rare. We could say that the underlying court shall just write up a quick findings of fact and conclusions of law, right? Like, here's what I determined, like date X, date Y, mitigating factors, this is how I come down. And that gives the court above something to review and to determine if the discretion was abused.
I'll tell you, I get quite a few motions to set aside defaults in my court, and quite frankly, I grant most of them.
Yeah.
But the reason I say it should be an abuse of discretion standard, I still think, because there's no record, so I simply indicated that the circuit court can just say whatever evidence they get in the circuit court is exactly the same evidence that was in the justice court or the municipal court. They can, I think we just statutorily authorize them to make that legal presumption. And then based upon that information, was it an abuse of discretion for the lower court to deny the motion to set aside the default? That way, that deals with the record issue, grants the circuit court that authority, and then creates I think, a pretty clean line to the decision.
I could also live with that.
Oh,
Jim,
Jim, you're muted.
How do you know that the evidence the circuit court is receiving is the same evidence that was presented to the justice or municipal court?
You don't, but we statutorily authorize the circuit court to make that legal presumption for the purposes of that. It's really creating a hybrid in a certain sense between a de novo review, but with creating the standard in terms of what the abuse of discretion is the standard in applying that evidence.
Or they could make whatever record they want and take evidence, but the standard, I think, should still be, did the underlying judge abuse discretion?
Right. But you have to presume that that judge had the same information in order to make that finding under abuse of discretion.
Or, presuming let's presume the law says the judge underneath received whatever information is received in the circuit court. If that were true, would that judge have abused their discretion?
Is there any other context with our appeals and review to the circuit court where we're doing something like this? It feels a little awkward coming from a non-court of record to like be reviewing for abuse of discretion. And then we're like creating new requirements for the justice and municipal court about findings of fact, or, you know, like that we don't impose for in any other circumstance, I don't think, do we?
Under my proposal, you would not be requiring the findings of fact. You would be assuming the legal presumption would exist that whatever evidence was presented in the circuit court was either presented or available to the lower court judge. And based upon that and what the circuit court judge has received, was it an abuse of discretion for the motion to be denied in the lower court?
Could you
Personally,
go on that further?
I think it's kind of an elegant solution.
Are we doing abuse of discretion in any other context? And maybe you guys know from your work in the scope of review work group?
No.
I
Not
think
that
this-
know of.
Yeah, I think this is the first area where that's come up. Yeah. But if a motion to set aside default judgment was denied in a circuit court and it went to the Court of Appeals, it would be an abuse of discretion standard. And here the circuit court is acting as the appellate court. And it seems to me makes perfect sense for that standard to be mirrored.
But we're not mirroring the Court of Appeals standards of review in the other contexts where appeals are being taken to the circuit court.
Well, sure.
Like we're recognizing a difference with those other contexts.
Yeah, well, circuit court, the Court of Appeals also does some appellate reviews on a de novo basis, just as the circuit court will be doing on for example, after a trial on an appeal. I litigated quite a few juvenile appeals a few years ago, and they were all de novo review.
Yeah, I'm not disagreeing on that. I think it doesn't seem though that with the scope of review, it's been a focal point of the group to try to mirror the Court of Appeals process for the circuit court that and this, it seems like we're treating this differently in a way that I don't totally understand what the rationale is behind it. Like, why is it important that this be abuse of discretion when we're not doing that in any other context, in any other type of case?
Yeah, so the rationale is literally because the defense bar, for example, in Marion County, uses the quirks of the appellate structure in order to make this court not useful for criminal proceedings. And my worry is that if we create a structure that allows that to happen, then this court will not be useful for civil violation proceedings either. So what I'm trying to do is assure that there is some finality, that plaintiffs have some finality in using this kind of court, because if they don't have that kind of, if everybody can just get a do-over, right? Even if they don't show up, right? Even if they show up 364 days later, and they just get an automatic do-over through quirks of the appellate structure that we create, then agencies will stop using the justice courts, and then we won't have this tool, and that will overburden the circuit courts in the future. That's my worry.
I think though that, like, for the circuit court to conclude that a motion to set aside would be proper, the defendant still well, one, again, we're just talking about violation cases, not civil cases here. The defendant would still need to convince the court that it meets one of the grounds in the statute, and so I think part of this might just be whether we trust the circuit court to make that determination. And also, I don't know if I can't speak to, what the defense bar is doing in your jurisdiction, but I wonder though whether, given there are different accounts of how widespread these motions are in the first place, like to what degree this is a significant problem. And also I would say that the scope of review is just one area where we can be kind of trying to address that concern, but another could be with the disposition that, I think our original proposal was that the case go back to the justice court. So that might address, I wonder, Judge Kidd, whether that would address your concern.
It's interesting that you framed it in terms of us not trusting the circuit court, because what I hear is people not trusting the justice court, right? In order to make reasonable decisions on default, right? And that's why, it sort of strikes a little bit at my heart, right? When I hear that's the tone that I get sometimes, right? Is just that you don't trust us. And we do make totally reasonable decisions. And so that's why I wonder why abuse of discretion is not the right standard, since it's the same standard that would apply to reviewing a circuit court judge.
Because a circuit court has a record to review for abuse of discretion, whereas a non-court of record does not. And that's why we don't use it in any other context when we're appealing to the circuit court.
Except my proposal solves that problem by saying the record created in the circuit court is to be taken as the information that the justice court or municipal court had when they made their decision. And then so that you don't have to worry about that. You're able to make that full presentation in the circuit court. And then once the circuit court makes its conclusions and findings of fact, it can determine whether or not there was an abuse of discretion based upon what the evidence it received.
Jim, I might ask you, because I know you had some thoughts on abuse of discretion in the write-up that you sent out last week. If you had any thoughts on this.
Having a court assume that have a legal assumption, like that the record made in the circuit court would have been or was the same record made in the justice or municipal court, is frankly a fiction. And we in the law sometimes engage in legal assumptions. They always make me uncomfortable, because in fact, we don't know whether the record made in the circuit court was the same record made in the justice or the municipal court. I guess I don't see the issue of this issue of trust. What I'm hearing from the judges is that they don't trust the circuit court judges to exercise their discretion in the same reasonable way that the municipal or justice court judge did, and that you want to rein that in by having an abusive discretion standard, even though there's no agreed upon record. I frankly don't feel too strongly one way or the other. I think the better approach is to have the same standard of review, the same de novo standard of review for these appeals as for all of the others. But if the only way we can get an appeal from the denial of a motion to set aside is by having a de novo standard, is by having a abusive discretion standard, then I'm willing to live with that.
I wonder how you guys feel about the proposal then to just have that be what is in working draft 4, and then that would be the default for our proposal. And then of course we'll have opportunities to like share that with the broader group moving forward. So if there are changes, then we could discuss it later, but abuse of discretion just be what we go with for the time being.
Can you say that again? I didn't follow.
Oh, since we have Jessica here working on working draft 4, maybe we should just have the abuse of discretion be the standard in working draft 4, and then there could be the opportunity for the broader group to weigh in, because they haven't seen this of anyone outside of this group. So we could just have that input later, but the default for now would be that we just go with the abuse of discretion. Since we have 2 people who strongly prefer that, one person who is a little agnostic on it, and then me. So maybe that would make sense for moving forward.
I think that sounds like a reasonable way forward.
Yep. Yes, I agree.
Before we do that, I just want to check with Jessica that that's okay and possible and is not going to cause significant challenges.
I think so. Looking at that March memo, that addresses the oral motions that you mentioned, Heather. It addresses the appeal, but I would be changing the de novo review to abuse of discretion. One thing I'm not sure that this language captures is importing enough of ORCP 71. Were there other grounds that the court could consider when deciding whether the motion for relief should have been granted or not?
I think two things I wanted to say. The first one was that I don't think it would be new grounds so much as just clarifying somehow that it incorporates those standards, because some of the language is just mirrors that, and there's a lot of case law about what those things mean. You know, like the excusable neglect, mistake, all of that. It's the same in both. And I don't think we had written anything capturing that we might be that we're thinking of them similarly.
So were you thinking of importing a reference or just dropping in a reference to ORCP 71 in the statute?
That's my recommendation.
Okay.
But that wasn't something that our memo said, and
Okay.
I'm not speaking on behalf of the group.
I think that's a nice idea. It adds clarity for the kind of people who navigate my court. Yeah, a little bit of clarity.
The one thing I'm troubled in ORCP 71 is one of the bases for relief from default there is newly discovered evidence, which I don't think comports with an abuse of discretion standard.
Mm.
It wouldn't really apply in a default judgment, or it's hard for me to like imagine how it works.
I'm just saying it's in ORCP 71, and so I don't think that should be there. What does ORCP 71 bring to the table that's not already in the statute as it exists?
So in our view, there were a couple of things. Like, one was that it potentially, carries with it the case law that's actually worked out a little bit of what these terms mean. And I don't think that there's been as much case law really at all about ORS 153-105. And then the other was that maybe it provides even more discretion to the court to set aside a judgment where it sees fit, because it discusses the inherent power of the court. It talks about clerical mistakes. It lists other things that don't entitle a defendant to relief necessarily, but that give the court broader discretion, I think.
You don't think that a clerical mistake would be applicable under the current statute? Because I set aside a default judgment if a defendant brings into me the fact that they got a notice that was a different date than from the when the hearing was actually set and the default was entered, which normally it's not, because we catch that. I look at the file to see what notice was sent, but let's say mistake happens. That would of course I would grant that in a heartbeat, and if I didn't, a circuit court certainly should and should tell me that I've used my discretion. I think that example is clearly covered by current statute.
If my client was in that situation, I would definitely argue it's covered in the situation. I think in that situation, I think I was hoping to just like make it abundantly clear. But I wouldn't discourage you, Judge Cross, from granting those motions. Can I just say one thing that I don't want to get lost to Jessica, which is I think part of the abuse of discretion standard, it sounded like a really important part of that too, was that we also ensure that the circuit court hear evidence. And so I don't think that that's in our current draft, because we were just, or I'm not sure if it is, because we were just assuming de novo. And so there may need to be additional language to ensure that the circuit court knows what it's allowed to accept as evidence.
Sure. I think currently, I think it said de novo review, which would include that, but if we're down doing the abuse of discretion, I have absolutely, to make it abundantly clear to the circuit court that they're able to receive any and all evidence, exhibits, and so on. I think that was in fact key to my suggestion in terms of how to get to this resolution.
Yeah,
That's what I was hearing. Yeah.
and I think, you know, that in getting around this sort of like weird legal fiction, I think we could say the standard is, if we just assume if the underlying judge had access to all the information that came out in the hearing, would they have abused their discretion? So that doesn't like create the presumption of a different hearing. I don't know. I think it's a little cleaner.
Okay, so to revisit, we are dropping in a reference to ORCP as the grounds upon, we're not,
I don't think so.
well, hold on. Would it be okay to drop in a reference, but make it clear that newly discovered evidence would not be one of the criteria, like everything except for that in ORCP 71?
Well, I just haven't heard anything in ORCP 71 that, you know, is not already covered by the statute. The example I was given was the clerical mistake, but that is covered by the current statute. I don't see any need to put ORCP 71 in the mix in this, you know, putting ORCP matters into the mix on, you know, violations, or, I mean, these are criminal actions. And I don't think that it's necessarily appropriate to be referencing the ORCPs.
I think that the idea was that it's a much more developed area of law and that some of the language does mirror. And so insofar as the language is similar, then that case, we would benefit from the clarity that case law provides. And then additionally, you know, I was just reading clerical mistakes because that's subsection A, but I think that the authority of the court under subsection C, the inherent authority of the court to set aside, you know, would give the court even broader authority where it sees fit. And so, and I'm not really sure what the concern would be with having those references.
What if the reference was ORCP 71B1 sub A, the mistake, advertence, surprise, or inexcusable neglect, and also part C, that clarifies that we have inherent authority? Because that's what I hear, is that those are the parts you want, and I think we all agree that those are useful.
That would be great. My one question is that if we say B, A, and then we say C, previously, as Judge Cross was articulating, we were understanding that that the mistake and advertent surprise, that language captured a clerical mistake. If we incorporate the parts of 71, all of that, most of them, but not the part about clerical mistakes, it might convey an intent to not allow it for clerical mistakes. So I just wonder whether, since we're incorporating, whether we could just do that for good measure, include the clerical mistake, and then the parts you said, just B1, subsection A, and then C, but not all the other stuff from B, like the, you know, the newly discovered evidence. And actually, there's a lot there.
There's also a little bit of a problem with the references, because I can refer to the letters. I can do Rule 71A, I can do Rule 71B1, but that A, B, C, D, E is not a true paragraph. And so I don't think I can drop that reference into statute. I would need to describe it. It's written in a very strange way that doesn't comport with the form and style of the Oregon Revised Statutes.
Could we just copy that, I guess that subsection part, yeah, it is what's just currently in 105, 153-105, the mistake and advertence.
Again, I don't really see any need for somebody who want to be involved. In fact, there's nothing that prevents a litigant from using cases that reference ORCP 71 if they would be pertinent or relevant to definitions or terms in the on the default, so setting aside the default judgment, because they certainly would have some degree of weight if no similar case law exists under the statute in 105. So, but I don't think dropping one ORCP reference into a criminal action statute makes a lot of sense, and I don't think that this adds anything to the anything that's not already covered by the statutory language.
I guess I'm Heather and Justice Kidd, I'm hearing that you think that it could potentially work, and I'm hearing from Judge Cross that you are not sure if it's necessary or not. I guess I want to ask Jim again if he has thoughts on this particular question.
Does not.
So
Not gonna bail you out, Amy.
I'm just concerned about the precedent of saying that we're incorporating ORCP into areas where it doesn't necessarily belong.
So are there discrete parts of ORCP 71 that we could just pull in? What I'm thinking of is we say, you know, mistake, comma, including clerical mistakes, comma, inadvertence, surprise or excusable neglect. There's the part from the memo that says, or that the court committed legal error in entering the judgment. And then we could maybe add something from C that just is, this isn't limiting the court's inherent power to relieve a party from a judgment.
Within a reasonable time.
Within a reasonable time, yeah.
I think I can live with that.
I think so too, and I think maybe it would just be a part of the legislative history when we talk about the measure that we understand these terms to have similar meanings across, so that it would be more clear that the case law applies. I heard what you're saying, Judge Cross, that you think the case law would be fair game, and I'd like it to be more clear. So maybe
I think there's some language in a couple of cases out there that you really want for your work, and I get that. I understand that.
I honestly don't have I honestly this time don't have a particular case in mind. Just a general sense from others I've talked to that it could be helpful.
And then I'm changing the standard of review to abuse of discretion. I am authorizing the circuit court to hear evidence or accept exhibits that are necessary to make the determination. And the standard is if the local court judge had access to the information in the record in the circuit court, would that court have abused their discretion when denying the order?
Thumbs up. Yes.
Okay.
I had a couple more questions, and it's possible that you guys have already sped past them, and I just didn't have enough background to do it or not. So I just want to touch on these two things really quickly, or as much time as you need to make sure that we talk about them. One of the questions I had was, are we all in agreement that if the circuit court denies the motion for relief from default judgment, nothing more happens in the circuit court? Are we okay? And then this was the other suggestion that I think was included in Jim's response to Heather's document was, if the circuit court grants the motion, I think the proposal or the idea was that then the parties could decide if they wanted to return to the local court or stay in the circuit court. Is that something that you all are comfortable with? And saying, hey, we've got, if the motion is granted, then the parties can decide whether they want to stay in circuit court and finish it up, because my understanding, based on Jim's write-up, is that can be a very short subsequent process, or they have the option to come back to the local court.
I think it should be remanded, as I said also in the last session, that I think it should be remanded to the lower court, then to proceed forward in whatever posture it's in.
I think that, you know, I think that the arguments for allowing the parties to keep it in the trial court would be, you know, that there could be some efficiency to the case not going back and forth. And also, I think, you know, Jim, if I was understanding correctly, in his email made a good point that it's possible that the matter could like be resolved that day if they were ready to proceed in the circuit court. And so if the parties agree, you know, the prosecution and the defendant, and, you know, nobody's objecting, even if the default would be that it would be remanded, I could see an argument for leaving open the option of just allowing them to proceed. If everybody was in agreement that that was the best course.
Again, if the circuit court is really acting as an appeals court, then it should be remanded, just as it would from any other appellate court when such a motion is granted. You get into other things which involve here, and Judge Kidd talked about different the judgments, the finances, or where things go that also come into play in these areas. So I just think that remand is by far the most logical and consistent approach with regard to these matters.
I would just say that I think the priority should be ease of access to the parties. And, you know, like, I don't generally have a strong opinion about the finances. Like, honestly, that all makes my head hurt a little bit, but I'm glad other people are much smarter about it than me. But, you know, if the parties are there, they're ready to go. In terms of accessibility for the parties and also resources for the state and the courts, I think having that option available could make a lot of sense. And from my view, like, access for the party and the defendant is really important.
You're also just presuming that the circuit court has the time on their docket just to do that. And now that they've done one hearing, now they're going to do the trial. I don't think, you know,
So
you're assuming they just have that time available. But that's
The
not
other thought I had is I don't know that the citing officer will attend the hearing on a motion for relief from default. I just wonder how often the other side will be ready to go for hearing.
If the defendant is pro se, of course, there would if the officer doesn't show up, the defendant's going to win themselves by default, because there will be no prosecuting attorney there. The officer is the prosecutor. So that would all depend if proper notice was sent to the officer to show up or not. And in many circuit courts, I will tell you that from what I've heard, that doesn't happen.
I'm persuaded somewhat by what Heather says around access and ease. And also I share some of what I think is the underlying concern that Judge Cross has around the finances. And so I wonder if we could write something that says, if both sides agree and the circuit court says that they have time, that you can roll right into hearing, notwithstanding any other piece of the law, if there's a judgment, that the judgment would be enforceable in the original court. I don't know.
That's not a very clear and effective piece of legislation, I don't think.
I don't know. I'm trying to.
I know you're trying to rebuild a bridge. I get it, but
I think that could work. I mean, so you know, both sides agreeing. If nobody shows up from the prosecution, it's difficult to say that both sides agree. So it's very difficult for me to imagine that a defendant shows up for a hearing on a motion to set aside, and the judge is like, you know, the judge says, sure, we can go forward with trial now. And oh, look, the police didn't come for your motion to set aside, you win. You know, like, I don't think a judge would do that. And, you know, because like the prosecution wouldn't have even had notice that there was a trial proceeding. And so I think that concern may not be something that would really play out.
well, it probably would. You know, for example, in Washington County, if you send notice to a sheriff's deputy for a trial, and if the word subpoena is not on it, they don't show up. If you put
I
the
mean-
words, if you put the word subpoena on it, even though, by the way, it's not really a subpoena, it's not any kind of legally enforceable subpoena, they show up.
But I think for
Sure,
a
then let's say
motion
no
to,
then.
for a motion to set aside, that wouldn't be a notice of a hearing. And if they didn't receive a notice of a hearing, I don't think the judge would go ahead with hearing when nobody even got a notice that there'd be a hearing. That's what I mean. I'm not disputing that, the procedures of the different police departments. I'm not privy to them.
Anyway, and I will come back. My primary concern is not the finances. That's a concern. But again, if the circuit court is acting as an appellate court, well, then remand is what an appellate court does in this circumstance.
I mean, yeah, I get it. And also, like, if I'm honest, like, my trials are normally 15-20 minute trials. And I'm just thinking about the, like, both the time of the defendant having to take 2 more days off work, and also the officer having to show up 2 extra times. Like, it's more time, it's more opportunities for things to fall apart in silly ways. I don't think it really serves justice. But, like, I get it conceptually what you're saying, Judge Cross. Like, I get it, but I'm just trying to be practical. I don't know. Also, it's not a hill I'm going to die on, right? Like,
If they're pursuing the process and they've spent this time, they've pursued the appeal, they've gone to the circuit court, it seems to me that they're invested in the process and they'll show up back for their trial in the lower court this time.
right, but does the officer want to show up? That means it's 3 different days the officer has to show up.
In my experience, Judge Kidd, the officers, they're getting paid. They don't really mind that much. The only thing they mind about is if they have to travel any great distance.
I guess I do kind of worry about the circuit court sets the motion to set aside the judgment for hearing and sends notice to the officer. And so let's say the officer shows up, defendant makes his case, puts on, says, I didn't show up for X, Y, and Z reasons. And the circuit court says, well, I think the local court would have properly exercised its discretion in denying that motion. And so there will be no hearing on the merits. And so the officer will have showed up for no good reason at all. I formerly thought it made more sense just to go ahead with the hearing, but the more I think through the logistics of it, Judge Cross, I know you're going to be shocked I'm agreeing with you.
But that's assuming the officer shows up. I mean, yeah, I'm not sure. I also think, though, that the parties might have other reasons that they want to just keep it there. For instance, the delay in having the matter considered. And I think too, the back and forth with the remand, it's a little confusing. I have clients who are confused by the different courts, whether that's reasonable or not, they are. And so that, I don't know, that's just another argument. I think, and I think that having the option for the parties to agree is sort of a compromise because, if the state or the city rather wants to keep the matter in the original court, then they basically get to unilaterally decide to do so, and it goes back.
I'm persuaded, right? Like, if it's literally like everybody has to agree, then, like, why don't we let people do what they want to do, right? Why don't we let people organize their affairs the way that makes sense for them? The money part is another part that the counties have to consider. But if literally the circuit court's like, fine, we'll hear it, and both parties want to hear it, like let's let them just be done with it. Let's give them finality, would be my pitch.
And again, this is only in a situation where not only did the defendant like appeal their denial of a motion to set aside, but the circuit court reviewed it for abuse of discretion and decided that under, no circumstance was like the justice court or municipal court's decision a legal one. Like, and so then, reverses based on abuse of discretion standard, which is a pretty high bar, and grants the motion to set aside. Now we're talking about whether both parties could agree to keep it in the court. And so I think there are a lot of steps here to, ensure that parties aren't just circumventing the original court at this point.
Again, that's not what an appellate court does. And again, the fact that there was a delay involved is most likely on the part of the appellant there, the defendant. Even if it was mistake or excusable neglect or inadvertence, the fact of the matter is that most of the time they had the date and they messed it up for some reason. There may be an excusable reason or it may not.
What would happen? I'm sorry,
Go
Judge.
ahead. No, go ahead.
What would happen if the law said the circuit court and the justice court in the respective counties shall make a decision about what shall happen, and it shall just be whatever they decide? Because maybe,
So you want to order them to have a local court rule on the topic.
yeah, and then maybe it may be that what works in Harney County doesn't work here, and what works in Washington County doesn't work in Lane County. Like, I don't know. What do you guys think?
It's kind of a weird one. Jimmy, you ever seen that something like a setup like that before in the statute?
Yeah, there is. I'm trying to remember where it is. There is a provision for judges to confer. Although I think it's like if you got multiple personal injury actions
there is.
filed arising out of the same case. Multiple actions filed arising out of the same incident filed in different circuit courts. The circuit court judges can confer and agree on which one of them will go to trial on, or something like that. So somewhere there is a provision for consulting between judges. Although I don't remember the details of it now.
There's a statute that says that we can get together with the circuit court and say that all small claims go through our court if we decide that's what we want to do. Right. So there's not a reason that we couldn't have a statute that says y'all decide.
What if we had the default being that all the cases are remanded, but we say notwithstanding this subsection, the court may adopt a local rule allowing a case to remain in circuit court for further proceedings if all parties agree, or something along those lines.
Or both courts would need to agree. Like if both
all
courts
parties
agreed that it could.
Oh, and both courts. Okay.
If both courts agree on to adopt a rule that would allow the case to stay in the circuit court if all the parties agree. Did I summarize that correctly, Jessica?
That's yeah. Both courts agree. I didn't have, but I can add that. Yeah.
I think that if you're leaving it to the courts to decide, I wouldn't place the limitation on the courts that they have to be. It has to be both the parties deciding. Like if the courts just decide for their own reasons that they want the case to go one way or the other, then maybe the court should just have the ability to decide that amongst themselves without limitation.
I also like that. And we could, if we wanted the all parties rule, we could just institute that in our county.
I don't have a problem with that suggestion.
I'll be interested to see if OJD has any thoughts about it, but it sounds like there might be precedent in another context, so hopefully it won't be an issue.
Yeah. Yeah, now that I think about it, I think there's also a statutory provision for judges to confer when a defendant has cases in more than one county. And sometimes it gets set, there's conflicting dates that I believe there's a provision for judges to confer and decide. which,
Just when you're,
which court gets to go
sorry,
first.
just when you're drafting it, you might make it be the presiding judge and the justice decide. That might make it clearer.
Okay.
It's, and the municipal, it'd be the chief judge.
Parties, I have 4 more minutes. I'm so sorry, but I have to go pretty soon.
I have a clarifying question because we've been talking about this a lot based on the defendant's appeal of the denial of relief, but the memo also talks about the state's appeal from the granting relief. And I just want to make sure that the provisions would be the same, just mirroring each other. Okay.
Jessica, if you have any other questions, I do not. I got through my questions. So shoot, and otherwise we can say thank you very, very much, but I want to give you the chance to ask any other clarifying questions.
I think I have enough to draft something, or basically to modify what is in the memo and put it in the work draft. And then we can all let the rest of the group decide that they hate it and want to change it.
Can I just say, like, thank you everybody for your like continued goodwill and like working through what felt kind of intractable for a little while and then feels like we've reached something that we can all live with. So I appreciate everybody hanging with us.
I will definitely second that. I know you guys have been bouncing things back and forth, I think since February. So thank you very much for sticking with it, and good faith all around, all that sort of thing. So thank you very much. If any questions come up that I can help with, please let me know. Justice Kidd, I know you need to go. And I otherwise will see you August 14th if I don't talk to you earlier, and please let me know how I can help.
Thank you, Amy.
Thank you, everyone.
Are we doing our Zoom check-in now?